Mr. Williams, can you state your name for the record, please?
Timothy, standing before the court as a state citizen and not U.S. citizen. My nationality is American.
This isn't your average courtroom showdown. What you're about to see is part drama, part legal education, and part sheer disbelief. On one side, we have the judge calm, authoritative, and bound by the rule of law. On the other side, a defendant who believes the law doesn't apply to him, armed with legal jargon pulled from obscure internet forums. This clash isn't just about charges, it's about reality versus fantasy. Stay tuned, because what starts as routine quickly spirals into a high-stakes verbal chess match, packed with drama, confusion, and more than a few jaw-dropping moments. And trust me, you'll want to see how it ends.
Now calling the matters of the people versus Timothy Tally Williams. Appearances for the record, starting with Mr. Williams, who's representing himself. It's okay, Attorney Vinik. He's representing himself.
Thank you.
You're welcome. All right, Mr. Williams, can you state your name for the record, please?
Timothy for the record, here by special visitation.
All right, and this is the date and time set for a final pretrial in this matter. We are scheduled for a jury trial on Monday. Attorney Mason has tendered to the court a witness list in this matter, as well as a special jury instruction served for you to be able to see in this particular matter. And let me ask again for the record, you know, you have the right to have an attorney. Would you like to have an attorney for you in these matters, sir?
Well, for the record, I'm here to serve a default judgment. I serve you, Andy and Mason, the affidavit. Back.
You did, and I'm in receipt. Oh, go ahead. I didn't mean to cut you off. Keep going.
Yes, on the first, and I gave you 15 days. It was 23 days I gave you, and I haven't received a rebuttal. So I served you guys with a default.
I don't know what a default is. So there's no default judgments in criminal matters. These are criminal matters.
Right out of the gate, notice how the defendant avoids giving straightforward answers. This is a classic tactic in sovereign citizen playbooks. Flood the court with irrelevant terms, hoping to derail the process. The judge, however, isn't budging. Judges are trained to filter out noise and zero in on the real question: are you going to trial, or are you not? This moment sets the tone for the rest of the hearing, a relentless tug-of-war between legal procedure and legal fiction. Now, watch how the judge tightens control while the defendant continues sidestepping responsibility.
So the only default that we have is if you don't appear to answer for a ticket, then the default that goes into place is your failure to answer for a ticket. Once it's established and it's here, I don't have to establish why these are tickets on the docket. That's why they have the jury and the bench trial options for you. These have been matters that have been, unless there's been a motion about a formally written motion about illegal stop or some constitutional violation, these tickets are considered to be valid and true.
No, I answered the affidavit of non-corporate existence.
So Mr. Williams, the answer to the question today is whether you're going to trial on Monday or not. That's all I'm here for.
Well, you guys haven't rebutted my affidavit.
Mr. Williams, again, I'm going to say, Mr. Williams, again, the question for today is whether you're going to trial on Monday or not. That's all. I have officers present. I have officers Evans present. I have Officer McCree present. I don't know if Officer Bush is coming as well, but they are here today to know whether or not they're going to be ready for trial on Monday. We set this jury trial out a long time ago for this trial on Monday. So are we going to trial?
Officers? What officer?
We have Officer Evans and Officer McCree present today.
And Judge, I have Officer Nunley. He's trying to check in right now. Faison Nunley.
Officer Bush is here also.
Thank you, Officer Bush.
Good
I didn't see. Good morning. Oh, it's Evans Williams. Okay, say thank you, Officer Bush.
Okay, we go
All
to
right.
trial.
Okay. So Monday we go to trial. Do you have a witness list or no, it's just you, Mr. Williams?
Yes, I have 3.
And here's where things escalate. The defendant starts claiming he's filed default judgments against the court, as if paperwork alone could wipe away criminal charges. But default judgments don't exist in criminal law, strictly a civil court mechanism. This move is more than just legally meaningless. It shows the defendant truly believes he can out-paperwork the system. The irony, the more he insists, the more credibility he loses in front of the judge. It's like trying to argue monopoly rules in a federal case that just simply don't connect.
No, that'll be it.
Okay. All right. So you have a drive unregistered, untitled motor vehicle and drove while unlicensed, and a no proof of insurance. That's one officer. The next officers are open alcohol driver, tinted windows, no seat belt, no driver's license, no insurance, untitled motor vehicle. And then the final officer is going to be drive unregistered motor vehicle, no insurance, no license ever acquired, and tinted windows. Okay.
And Your Honor, if I may interject, since he does have an email, I can copy those tickets and email them over to him so that
Please.
he can have them. I'll come down and get those. And I will
Appreciate
email
it.
those tickets over to you, Mr. Williams.
Okay.
So that way
And
you can see what
for
the
the record,
tickets
can
say.
are we able to argue these matters right now, or are we going to trial? Is
You
it
said
possible
you
we
want to
can?
have a trial. What you want to argue?
Yeah,
You
but
want
I'm
to talk
saying
to
like
Attorney Mason?
what was that?
I said you want to talk to Attorney Mason just briefly in a breakout room and see if y'all can resolve any of the tickets.
Well, we was just emailing, and I don't know if it meant anything to her, so that's why I wouldn't just take it to trial. And
Well, because you can't say I just want you to dismiss it because I'm not a citizen. That's not gonna work. Or I just want
Oh
you to
no, that's
dismiss
not
it.
it. I got laws stating that all this is frivolous, but I'm saying, can we argue this right now, or do we?
A
Can we
lot of
resolve
people
it
would say
today?
the
Or
laws are frivolous. Well, yes, if you have some argument that you would like to make, you can make it that way. I can rule, and that way we can go to, if we're gonna move forward to trial, we can go to trial. Yes, Attorney Soroki.
Yeah, if you like, I could speak to Mr. Timothy Williams in a breakout room for a few minutes, explain the legal system to him.
Yes, can you?
no, sir.
Do you want to make your argument first, Mr. Williams, or do you want Attorney Soroki? Just he wants to give you a little feedback. That way you'll be prepared for Monday's trial. No, all right. He doesn't want it, Attorney Soroki.
This is the turning point where the defendant starts throwing out accusations against the judge and prosecutor, even claiming they're being sued in some fantasy jurisdiction. It's bold, it's dramatic, but it's also completely ineffective. The real drama here isn't in the substance of his claims, it's in the disconnect between his conviction and the legal reality. The judge knows these arguments are dead ends, but still has to patiently let him speak, if only to preserve due process. For viewers, this is both frustrating and fascinating, watching someone so confident, yet so catastrophically wrong.
Timothy Williams. Can I have appearances? First Attorney Mason, then Mr. Williams.
For the record, Your Honor, Diachiku Mason, City of Detroit, 43471.
All right. Mr. Williams.
Yes, Timothy before the court, here by special appearance as a state citizen, not a U.S. citizen.
Okay. Changes every time. All right, you want to make a motion or you want to make an argument as to these tickets? You can go ahead at this time, Mr. Williams.
Okay, for the record, Shapiro versus Thompson states that all citizens must be free to travel throughout the United States, uninhibited by statutes, rules, or regulations, which unreasonable burden or restrict movement. Did you get that?
I'm listening. I'm just writing down. You see, I got my notepad.
Okay.
I'm writing down
Okay.
notes.
And then the Murdoch versus Pennsylvania, the Supreme Court decided that a state cannot arbitrarily or erroneously convert a secure liberty, in this case, the secure right to travel, into a privilege and charge of or issue a hold on. A state can't arbitrarily or erroneously convert a secure liberty into a privilege and issue a license and a fee for it, meaning we don't need license or insurance to travel throughout the land. And Murdoch versus Pennsylvania states no state convert secure liberty to a privilege. No, Shuttlesworth versus Pennsylvania. No, Shuttlesworth versus Birmingham, Alabama. You can ignore the license and engage in the right with impunity if you happen to have a license. And back to Murdoch versus Pennsylvania, no state may convert a secure liberty into a privilege. So no state has a right to require you to have a license. Hold on.
Okay, so that's your argument as far as no state can force you to have a license
Require.
because it's a constitutional right to travel.
Which is our First Amendment.
So this right to travel was about a welfare case, Mr. Williams, where she wanted to go to a different state. And they told her that because she didn't have established residency in that she was going to be denied services.
Right, and that violated her.
Right, because it's talking
right
about services. She needed to take care of her child. She was 19 and she was pregnant.
But you avoiding the effects of the case. Even though that she filed a lawsuit against the state for denying her privileges, but the Supreme Court ruled that the Supreme Court ruled that can't happen because that also be violating her right to travel throughout the states, throughout the land.
Receive the benefits that she needs in order to take care of herself and her child.
Yes, but you're missing the argument that the Supreme Court has stated. That'll be violating her First Amendment right, life, liberty, and pursuit of happiness.
Notice the phrase special appearance in sovereign citizen circles. This phrase is treated like a magic incantation that erases jurisdiction. In reality, it has no effect in criminal cases. Courts operate on evidence and statute, not linguistic tricks. But to adherents of this ideology, saying special appearance feels like armor against prosecution. This moment as Kiat shows how deeply some defendants believe that the words they use can change the law itself. Powerful glimpse into the psychology driving these bizarre courtroom encounters.
You see that ruling? I don't want you to miss that fact. That's what they ruled.
They said the closest the Supreme Court has come to overturning Shapiro Thomas was in 1995 with Anderson versus Green, California Welfare and Interstate Code annotated section instituted a 1-year residency requirement for welfare aid, violating Shapiro versus Thompson. Both lower courts in California affirmed that it violated Shapiro versus Thompson and granted the injunction. Due to the procedural issue, California's residency requirement never went into effect, creating no justifiable controversy action and no actual issuance for the court to rule on. whether they receive a waiver from the Secretary of Health or Human Services to set aside Shapiro versus Thompson, making the residency requirement pseudo-legal. The waiver was challenged again, and it's holding that the state court and the Secretary of HHS had not adequately considered public comment on the issues. So this just talks solely about, even talks about the social impact. The social impact and the legal impact is that you can go different places, and we as the governments of each state still have a requirement to take care of those citizens within our state. This is about welfare. Yeah, this is about the welfare system and the ability for people. You cannot stop people from traveling. I don't see anything in here about a driver's license.
Look, the decision of the court.
Right, she has the right to go places.
Look, the court reaffirmed the right to travel under the 14th Amendment Privilege and Immunities Clause in Suez versus Roe. So they conferred it to another case. But the conclusion of the case like that would be violating her right to travel. It have something to do with the welfare, but
travel or to go to another state is because then they're saying once she gets to that state, she has to establish some type of residency. And what they're saying is that if she doesn't have that residency, she wouldn't get the services needed. And so they're saying you can't say, oh, you can't go to this state and not get the stuff that you need to take care of yourself and your family just because you're not. I can't stop her. I can't say you can't move to this state and then we're gonna block everything. I can't do that. Right. This is not about a license.
Which will violate the right to travel.
No,
that was the decision of the court. I'm not making that up.
You aren't, but you're not understanding what their decision was based on. Yes, you have the right to travel, but this is concerning services.
So if I chose to carry a weapon, I will be bearing arms.
If you chose to carry a weapon in the state of in Illinois, that's an automatic. You're not allowed to carry weapons at all in the state of Illinois unless you're a law enforcement officer. So if you traveled over the state lines and you went to Illinois and you tried to carry a gun, they would tell you no.
But that's irrelevant, Your Honor. We're talking about the state of Michigan. I have a right to bear arms, but you will call it receiving a facility. But the Constitution of Michigan states that I can bear arms, but
because once again, and we had this conversation already, the states can make stuff more, the localities can make stuff, they can, and it's a state law anyways, but they can be harsher than the U.S. Constitution, but they can do something that would take away from the U.S. Constitution. So they're not taking away your right to bear arms, they're just putting parameters around that right. And recently it was challenged at the Court of Appeals when someone tried to say that the people have the right to bear arms and that seeing a bulge or doing stuff like that didn't equate to it. And the Court of Appeals has said and ruled that does give probable cause for an officer to ask about whether or not they have the licensing because the state has determined that they need to have the licensing. So if the state determines that there needs to be a certain licensing in place and that rule or that is violated, then that has to go forward.
But that's kind of irrelevant.
Okay.
And now, the defendant begins what I like to call the case law carousel. He rattles off old rulings: Murdoch v. Pennsylvania, Shuttlesworth v. Birmingham, as if they automatically apply here. But quoting a case doesn't mean it supports your position. Murdoch dealt with religious pamphlets, not traffic laws. Shuttlesworth was about protest rights, not licensing. By twisting these cases out of context, the defendant creates the illusion of authority without substance. To the untrained ear, it might sound impressive. To anyone familiar with law, it's smoke and mirrors.
Our secure liberty, First Amendment, is the right to life, liberty, and pursuit of happiness.
Mm-hmm.
Right to travel throughout the United States of America.
Right.
Freely and unencumbered. We're not causing harm to anybody. We just obeying the constitutional rights. Exercising our constitutional rights, which is the court is here to help protect them. I'm relying on the constitutional rights. I'm not just out here willfully nilly, like United States versus Bishop. United States versus Bishop.
But you are, because you're only taking the part that you want to be applied to you. So you are out here willy-nilly. Because if you were following, no. If you were following everything, you would want to follow everything and all the rules that were put into place. So all that
No, I'm following laws, not
following
rules.
what you want to follow. And that's no. We talked about how that leads to anarchy. People can't do whatever they want to do. They say that I can follow only this. That's no. That's like me coming one day and saying, I want to practice law and I want to be a judge, and I haven't gone through any of the things to become a judge. That's not how it works.
I see how you put it,
I can't sit up there with a fake P number. They wouldn't let me do that.
I see how you put it, but that's not true. What about Title 18 USC Section 241?
So Williams, do you want a trial on Monday or not? You can't argue this stuff to the jury.
Yeah, I want to go to trial, but I can't.
Okay. You can't argue this stuff to the jury. You can argue that maybe something, making sure that they didn't check the things. Like, you have to follow the law. I have to treat you as an attorney in that place on Monday. So I have to treat that you know how to practice and go about the way of law. And these different things, like, you can't just give the jury cases and stuff like that. That's not what it's going to be about. And you'll most likely end up with objections that I'll have to sustain, because it's going to be talking about the facts of these particular cases where the officers came today to show up. So it has to stick to those things about what the officers came to argue about, or what Attorney Mason will make the argument for, and the officers came to testify about.
What are they testifying about?
About these different stops.
Which is unlawful.
Different tickets. Okay. Well, I gave you plenty of time to write a motion about unlawful, and you did not want to.
So now we're here. I gave you affidavits stating the facts, what you needed, and
exactly. And the facts are to be argued before a jury. If they differ from these facts that on the tickets, we're here to talk about these tickets. I've already made my ruling long ago that they had the right to stop, and that these tickets are the tickets for which they wrote them for.
Yes, they have a right to stop persons, but I'm not a person. I'm a human being. I have no contract with the Secretary of State. I'm traveling.